Welcome. You have accessed the North Carolina Auctioneer Licensing Board mandatory 2-hour continuing education course on North Carolina auctioneer licensing laws and rules to include ethics and custodial account management. This program is being offered live at 12 different locations throughout North Carolina. Additionally, those completing this course through the online version will also satisfy the mandatory 2-hour course requirement. Credit for this course is necessary in order to renew your license for the 2018/2019 license year. Instructions will be given at the end of this program to advise as to what you'll need to do to verify that you completed this 2-hour mandatory course and received proper credit. Regarding content, today we will be talking about auctioneering law and rules, then ethics, and then at the end of the program we are going to discuss 4 real case studies where licensees unfortunately made some really bad choices. You may have noticed the North Carolina state seal on the first slide. Here it is again because I want to point out the state motto in Latin at the bottom, Esse quam videri. That translates in English to be rather than to seem. Keep that in mind as we will revisit that motto later on when we talk about ethics. The board's mission statement reads as follows. The Auctioneer Licensing Board is responsible for the administration and enforcement of the auctioneer's law, which establishes specific standards of conduct that serve to protect the public, affords a means of redress of grievances of any person suffering damage by reason of misconduct relating to sales at auction, and provides a means of monetary restitution for loss suffered. Licensing auctioneers and auction businesses increases public confidence in the profession by providing a means of determining the ability, general knowledge, integrity, and good character of those permitted to practice, and a means of deterring fraudulent or dishonest dealings and unethical conduct. It is the responsibility of the Auctioneer Licensing Board to assure that the qualifications and activities of those engaged in auctioneering are in accord with the law and in the best interest of the public, to receive and act upon license applications, issue, suspend, or revoke licenses, adopt rules and regulations, and take such other actions as may be necessary to enforce the provisions of the auctioneer's law. The licensing board is not a board of arbitration and has no jurisdiction to settle disputes between parties concerning the rate or division of commissions, pay of assistants, and similar matters of contract. Basically, the mission statement boils down to the North Carolina Auctioneer Licensing Board exists to protect the public and to promote professionalism in the auctioneering industry in North Carolina. Among the board's listed powers and duties are those involving discipline. North Carolina General Statute 85B-8A reads, the following shall be grounds for the assessment of a civil penalty in accordance with General Statute 85B 3.1b, or the denial, suspension, or revocation of an auctioneer, auctioneer apprentice, or an auction firm license. 1. any violation of this chapter or any violation of a rule or regulation duly adopted by the Commission. 2, a continued and flagrant course of misrepresentation or making false promises either by the licensee, an employee of the licensee, or someone acting on behalf of and with the licensee's consent. 3, any failure to account for or pay within a reasonable time not to exceed 30 days funds belonging to another which have come into the licensee's possession through an auction sale. 4, any false, misleading, or untruthful advertising. 5, any act of conduct in connection with a sales transaction which demonstrates bad faith or dishonesty. Six, knowingly using false bidders, cappers, or pullers, or knowingly making a material false statement or representation. 7, commingling the funds or property of a client with the licensee's own, or failing to maintain and deposit in a trust or escrow account in an insured bank or savings and loan association located in North Carolina, funds received for another person through sale at auction. 8, failure to make the required contribution to the fund, meaning the recovery fund. 9, the commission or conviction of a crime that is punishable as a felony offense under the laws of North Carolina or the laws of the jurisdiction where committed or convicted, or the commission of any act involving fraud or moral turpitude. 10, failure to properly make any disclosures or to provide documents or information required by this chapter or by the Commission. 11, a demonstrated lack of financial responsibility. What are some of the duties of an auctioneer or auction firm? There's a duty of fairness to a seller, a duty to act in good faith, a duty of competence, a duty to exercise ordinary care and skill in the performance of the duties confided to him or her, a duty to educate the seller to ensure that they understand their options, such as making sure that the seller knows the difference between a reserve auction and an absolute auction. The auctioneer should go over thoroughly the options with his or her seller to ensure that they understand the specifics of the contract they are about to enter. Another duty is the duty to the buyers at the day of the sale to understand the terms and conditions of the sale. This can be done both with your announcements and with signage and handouts. The auctioneer or firm can increase their professionalism and appearance to sellers by educating the sellers. They have hired you for a service. The auctioneer's firm benefits in the end by realizing that the seller knows and understands all of the options that are available and can make an informed decision as it relates to the written contract. The auctioneer has a very high duty to the seller, and that's called a fiduciary duty. What does fiduciary mean? According to the Merriam-Webster dictionary, fiduciary means of, relating to, or involving a confidence or trust, such as either A, held or founded in trust or confidence, such as a fiduciary relationship or a bank's fiduciary obligations, or B, holding in trust. That's the definition that we'll focus on. The auctioneer's fiduciary duty to the seller exists because he or she is holding in trust either the property that belongs to the seller or the proceeds from the sale at auction that were achieved on behalf of the seller. The auctioneer is acting as a fiduciary in his or her relationship with the seller. In fact, this concept of a fiduciary duty that an auctioneer has is most likely the primary point that we'll focus on today. Because of the trust that the seller has put in the auctioneer with his or her property, or then the proceeds from the sale of their property, an auctioneer's fiduciary duty is to that seller. This means that the auctioneer is an agent for the seller and must act in the best interest of the seller. A fiduciary duty is a very high duty and brings with it very high responsibility. In short, your fiduciary duty to your seller means that you must do the best job that you can on behalf of that seller, and then hold that seller's property and then the proceeds from the sale of that property in trust and on behalf of that seller. What about your duties to buyers and other bidders? Any thoughts on that? Do you have a fiduciary duty to your buyers and other bidders? Well, you certainly do have duties to buyers and other bidders. You owe them the duty of good faith, the duty of fairness, the duty of professionalism, the duty to make appropriate disclosures and make no misrepresentations, and you owe them a duty to make an effort to correct any mistakes in a fair, ethical, and legal manner. This is all true, but does an auctioneer have a fiduciary duty to buyers? What do you think? The answer is no. While the auctioneer does owe all of those duties that we talked about on the previous slide to buyers and bidders, the auctioneer does not represent the buyers or bidders in the same capacity that they represent the seller. They are the agent of the seller, which brings with it the very high responsibility of being a fiduciary to that seller. There's actually case law in North Carolina on this issue. A 2003 North Carolina Court of Appeals case entitled Green versus Rogers Realty and Auction unanimously upheld the trial court's summary judgment granting in favor of the auctioneer defendant because the defendant only represented the seller, and thus the defendant owed no fiduciary duty to the plaintiffs in that case. This is a published North Carolina Court of Appeals case stating that the auctioneer's fiduciary duty is to the seller and not to the buyer. North Carolina's auctioneering licensing laws are found in North Carolina General Statute 85B. We are now going to discuss the statutory provisions involving contracts, trust accounts, record keeping, reporting requirements, auction firms, and advertising. So what does 85B say about contracts and the auctioneer and owner requirements? NC General Statute 85B-7A says that no licensee shall conduct an auction in this state without first having a written agreement with the owner of any property to be sold. The agreement must contain the terms and conditions upon which the auctioneer received the goods for sale. The licensee shall provide the owner with a signed copy of that agreement and shall keep at least one copy for his own records for 2 years from the date of the agreement. Copies of all contracts shall be made available to the Commission or its designated agent upon request. Under General Statute 85B-7A, an auction contract has to be a written agreement that contains the terms and conditions, but it doesn't really dictate what the specific terms and conditions need to be. It just says that you have to give the owner a copy and that each licensee is required to keep a copy of the fully executed auction contract for his or her own records for 2 years from the date of that agreement, and that copies of all contracts shall be made available to the representatives of the Commission upon request. That's it. In practice, though, it's a good idea to try to anticipate on the front end what types of issues might arise during your auction or after your auction and address those in your contract. Doing so might help you avoid future conflict with your seller. What are some important or helpful provisions that you use or can think of that would help make a strong auction contract? Former board counsel Neil Yarborough authored a very helpful practice tip article on contracts for the fall 2015 NCALB newsletter. I'm going to read that in part now. Mr. Yarborough wrote that a good contract makes for a good relationship. In many instances, it is the difference between receiving a notice of a license complaint or not, or the difference between being sued or not. The better written understanding that you have with your seller and any potential buyers prior to the sale as to each party's responsibility, the less chance that there will be a problem to arise in the future. The exact wording of your contracts is a matter for you and your attorney to work out. However, from the NCALB's perspective, a clear provision in your contract addressing foreseeable issues may prevent a license complaint and potential disciplinary action. While reviewing any of your existing seller contracts for possible improvements, please also ensure that the following areas are addressed: the auctioneer's fees and expenses, a detailed description of the goods to be sold, a time frame of the sale and duration of the contract, the terms of sale. Is it absolute? Is it subject to any liens, etc.? The responsibility for delivery of goods, deposit requirements and payment schedules, and also the owner and auctioneer split of any forfeited deposits. The above list is not intended to be exhaustive, but it is a good starting place. While reviewing your owner-auctioneer contract, it is also a good idea to review your standard terms of sale at auction to make sure that they are compatible with your owner-auctioneer contract. In addition to the potential issues that Mr. Yarborough addressed in his practice tip article, what are some other issues that you might want to address in contracts? What about buyer's premium? Have you addressed buyer's premium in your contract if that's a provision that you want to use? What about a cancellation of the auction? Is that addressed in your contract? What's going to happen if an auction is canceled? Similarly, how do you address withdrawn items? All these and many more are issues that are areas of foreseeable potential conflict that you can avoid trouble down the road if you address them properly on the front end in your contract with your seller. Now we're going to discuss custodial accounts, including money handling requirements, miscellaneous information, and what to do in the case of escrow disputes. NCGS 85B-7.1 addresses the handling of clients' funds. In Section A, it states that each licensee who does not disperse all funds to the seller on auction day shall maintain a trust or escrow account and shall deposit in that account all funds that are received for the benefit of another person and are not dispersed to the seller on auction day. The licensee shall deposit funds that are not dispersed on auction day with an insured bank or savings and loan association located in North Carolina at or before the time of all final settlements. The auctioneer shall provide the seller or consignor with a settlement statement, which includes a description of all goods sold, the selling price of the goods sold, the net proceeds due to the seller or consignor, the names and addresses of the person receiving the disbursement, and the amount of the disbursement. All settlement statements shall be signed by the licensee or the licensee's agent and by the person receiving the disbursement. So if you are not going to disperse the sales proceeds on the day of that sale to the seller, you must place the sales proceeds or any earnest money deposits into your trust account. And by the way, 21 North Carolina Administrative Code 4B.0603A says that you must deposit those proceeds within 3 business days into your trust account. Additionally, NCGS 85B-7.1A says that all settlement statements shall be signed by the licensee or the licensee's agent and by the person receiving the disbursement. As an auctioneer or auction firm, you either need to have that signed settlement statement back from your seller before you pay them, or you get that signed settlement statement at the same time in person when you pay them. Regarding the North Carolina bank or savings and loan provision in 85B-7.1A, if you are out of state, you will need to keep your money from North Carolina auctions in a bank that does business in North Carolina. There are no specific regulations regarding how those accounts are set up. They can be called a trust account, an escrow account, or specifically a custodial account for sellers' proceeds. But if you are out of state, or anybody in state too, the money from North Carolina auctions put into one of these custodial trust or escrow accounts must go into a bank that does business in North Carolina. They can certainly be based elsewhere, but they have to have at least a branch in North Carolina. So what does General Statute 85B-7.1 say about trust account record keeping requirements? Under Section B, it says that each licensee shall maintain for not less than 5 years complete records showing the deposit, maintenance, and withdrawal of trust or escrow funds and the disbursement of funds on auction day. Records of the disbursement of funds on auction day shall include a copy of each receipt or settlement statement issued when the funds were dispersed. The Commission or its designated agent may inspect these records periodically without notice and may also inspect these records whenever the Commission determines that they are pertinent to an investigation of any specific complaint against a licensee. So to clarify, if you pay your seller on the day of the auction, you have to keep those records for 2 years. If you do not pay your seller on the day of the auction, you have 3 business days to get those proceeds into your escrow/trust/custodial account for seller's proceeds. And in either case, you have to have a signed settlement statement at or before the time that you pay your seller. For any auction where you pay your seller on the day of the auction, you are required to maintain those records for 2 years. If you do not pay on the day of the auction and are required to utilize a trust/escrow/custodial account for seller's proceeds, then you must maintain those records for a period of 5 years. So what about the specifics of those settlement statements? At or before the time of all final settlements, the auctioneer shall provide the seller or consignor with a settlement statement, which includes a description of all goods, the selling price of the goods sold, the net proceeds due to the seller or consignor, the name and address of the person receiving the disbursement, and the amount of the disbursement. So what can you pay out of that trust, escrow, custodial account? What can that money be used for? You can pay the net proceeds to the seller or any person that the auctioneer knows is entitled to payment. 2, that money can be used to pay lawful charges against the property which the auctioneer or auction firm shall, in its capacity as an agent, be required to pay, such as a lien against the property. Or 3, to obtain any sums due to the auctioneer or auction firm as compensation for your services. So what do you do, according to the law, when there is a dispute between you and the seller or a buyer and the seller, and the money is in the escrow account? 21 North Carolina Administrative Code 4B.0603F reads that in the event of a dispute between the seller and buyer of goods or property, or between the licensee and any person in whose name trust or escrow funds are held, the licensee shall retain said monies in his trust or escrow account until he has obtained a written release from the parties consenting to its disposition, or until disbursement is ordered by a court of competent jurisdiction. So either everybody comes to an agreement and you receive a written release, or you get a court order telling you how to disperse that money. Until then, you're supposed to retain that money in the escrow account. Record keeping. What are some of the records that an auctioneer or auction firm should retain? Those include contracts, trust account records, sales records, announcements, your intake paper trail, meaning consignment records, and video recording or photographs. Some of those are mandatory. In fact, most of them are, but certainly there's no mandate that you take video or photographs, but it's a good idea to hold on to those in case there's a dispute that needs your attention later on. NCGS 85B-7.1 addresses the conduct of auction and records, and we've already discussed Section A, requiring the written agreement for any auction conducted in North Carolina, and that you must provide the owner with a signed copy of that agreement. We're going to discuss the provisions in Section B on the next slide. So as far as C is concerned, it simply says that all licensees shall have their licenses available at each auction that they conduct. And your pocket card certainly suffices to satisfy that requirement. I mentioned intake paper trail a couple of slides back. Under NCGS 85B-7B, each licensee shall maintain consignment records and enter into them, upon receipt of the goods for auction and before sale, the name and address of the person who employed the licensee to sell the goods at auction and the name and address of the owner of the goods to be sold. You must have consignment records. Additionally, those consignment records shall contain an adequate description of the goods to be sold and shall be sufficient to positively identify each item. Consignment records shall be open for inspection by the Commission or its designated agent at reasonable times. An example of insufficient consignment records would be an auctioneer that has multiple box lots and only identifies them as such. Box lot, box lot, box lot. The auctioneer needs something at least a little more descriptive. As example, box lot of tools, box lot of toys, and so on and so on. Otherwise, those records are not sufficient to positively identify each item. This is an example of where photographs can come into play and be very helpful. If you've got a box lot and say it's box lot number or box lot A, and you take a picture of it and you label that picture as box lot A, and your sales records show that box lot A was sold to a certain person, then you've covered yourself under the requirements of the record keeping provisions in GS 85B. I just mentioned sales records. What does the statute say about sales records? Under NCGS 85B-7D, each licensee shall maintain sales records which identify the purchaser of all goods sold by name, address, and when possible, telephone number. The sales record shall contain an adequate description of the items sold and must be sufficient to positively identify the owner of the property. Further, 85B-7D states that sales records shall be maintained for a period of not less than 2 years from the date of the sale. Sales records shall be open for inspection by the Commission or the designated agent at reasonable times. Of course, this 2-year sales record retention requirement is the same for all your record keeping. It's 2 years if you're paying your seller on the day of the auction. Otherwise, you'll have to put the money in that escrow trust custodial account for the seller's proceeds, and you'll have to maintain all of those records for a period of 5 years. Reporting requirements. There are certain things that you have to report to the board, and there are timetables attached to those requirements. Among the things that have to be reported are change of address, change in business relationship, and lawsuits or criminal charges. In the auctioneering rules, specifically 21 NCAC 4B.0601A, it says that all licensees shall notify the board in writing of each change or addition of residence or business address, including mailing address, and change of trade name, assumed name, or combination of names under which the licensee conducts business related to auctions. In addition to your residential address, you may have multiple locations where you regularly conduct business. Each of those business addresses must be reported to the board. Similarly, it's quite all right to have multiple DBAs, doing business as names, which are also known as trade names or assumed names. But each one of those assumed names must be reported to the board. Other reporting requirement provisions under .0601 include corporate licensees. If you have a change in the directors or officers of the corporation, that must be reported to the board. Similarly, a partnership licensee must report any change in partners. An auction firm licensee must report any change in designated persons, including any deletions of designated persons, and all changes, whether it's address, name, ownership, designated person, etc., all of the changes that we have discussed on the last couple of slides must be reported to the board in writing within 10 days. Regarding criminal charges, 21 NCAC 4B.0405A says that any arrest and or conviction of any misdemeanor involving dishonesty, deceit, fraud, or misrepresentation must be reported to the board. And any arrest, charge, or conviction of any felony, regardless of what it involves. Convictions are considered to be verdicts of guilty, pleas of guilty, and pleas of nolo contendere, which means no contest. In each of these, notice must be given in writing to the board within 30 days of each occurrence. Once you're arrested, you've got 30 days to report that to the board. If you're charged soon after that, that must be reported to the board. And if you're convicted, that must be reported to the board. In practice, once you report the first one to the board, board staff will require you to keep it updated in writing of any developments until the case is finally disposed of. Now remember, you have to report any felony, regardless of what it involves, and you have to report misdemeanors if they involve dishonesty, deceit, fraud, or misrepresentation. Similarly, 21 NCAC 4B.0405B deals with civil lawsuits. Those that need to be reported to the board involve any civil lawsuits involving any allegation of gross negligence, dishonesty, fraud, misrepresentation, or incompetency. Also, any civil lawsuit that in any manner relates to auctioneering must be reported to the board. Notice must be given in writing to the board within 30 days of each occurrence. So when that lawsuit is filed and you're given notice of it, you must report that to the board within 30 days. The board is also going to, as a matter of practice, require you to report the final disposition of those civil lawsuits. In addition to criminal situations and civil litigation, 21 NCAC 4B.0405C deals with administrative proceedings in other states. Any licensee or designated person must report any and all administrative proceedings commenced against them which involve any potential disciplinary action against any auction or auctioneering license they hold in another state. Notice must be given in writing within 30 days of each occurrence, and like the others, the board is going to require that notice is also given when final disposition is achieved. To clarify, the provisions of 21 NCAC 4B.0405A, B, and C all apply to every auctioneer, apprentice auctioneer, and for the auction firm for each principal and for each designated person. Now let's discuss auction firms. Auctioneering activity is restricted to the persons named in the license as a designated person. That authority does not inure to any others. Subsequently named designated persons who have applied and been approved obviously can perform auctioneering activities on behalf of the auction firm once they've become approved by the board. So who can be a designated person? Anyone who is at least 18 years old with proof of a high school diploma or evidence of the equivalent may complete the application process and take the firm exam. Designated person status is subject to NCALB approval. Licensed North Carolina auctioneers and real estate brokers are exempt from the firm exam requirement, but must still submit a complete application including current criminal background check. Real estate broker designated persons may only deal with real estate and no personal property for the auction firm unless they are also a licensed North Carolina auctioneer or have taken and passed the auction firm designated person exam. What are the designated person responsibilities? When an auction firm has a non-auctioneer who has passed the firm designated person exam, that person may perform all duties associated with auctioneering except bid calling. A licensed auctioneer designated person for a firm can obviously perform all auctioneering functions for that firm. Advertising. The provisions for advertising requirements for auctioneers are found in 21 NCAC .0602 subsections A through L. All of these requirements are designed to protect the integrity of the auction process and stem from the statutory prohibition against any false, misleading, or untruthful advertising, as stated in NC General Statute 85B-8B4. So what are some of the provisions? One example is absolute auctions. If an auction is advertised as an absolute auction, more than half of the items to be sold at auction must be sold absolute. It is okay to have items that are with reserve, but those items must be specifically designated in all advertisements and announcements, and there must be less than half of the items that are sold at auction that are with reserve when the auction is advertised as an absolute auction. Similarly, estate auctions. If an auction is advertised as an estate auction, more than half of the items must be from one specific estate. There can be others, but more than half have to be from one. An additional provision includes in an estate auction, the advertisement must designate whether the estate is for a living estate or a deceased estate. It is not necessary to provide the name of the living or deceased estate holder. Often an auctioneer will for marketing purposes, but it is not a requirement, only whether it is a living or deceased estate. These rules apply to all auction advertisements, whether they are free or paid advertisements, and whether they are print, online, or otherwise. All auction advertisements must include the name and license number of the auctioneer or auction firm. However, an advertisement that is considered to be a trolling ad or holding ad, simply announcing that the auctioneer or auction firm does auctions and does not advertise a specific auction at a place and time, and date and time, that advertisement does not have to include the name and license number of the auctioneer or auction firm. However, it's probably a good idea So the North Carolina auctioneer advertising regulations are found at 21 NCAC 4B.0602. Among those provisions, it says that in all advertisements relating to an auction, the auctioneer's, apprentice auctioneers, or auction firm's name and license number shall be conspicuously given. If an auctioneer is working for or in conjunction with an auction firm, such relationships should be disclosed and both license numbers shall be conspicuously given. Again, this and all of the advertising regulations apply whether it's a print ad, an online ad, a radio or television ad, or even a billboard advertisement. We discussed estate sale auctions and absolute or without reserve auctions previously. Similar restrictions involve bankruptcy sales. .0602C says, it shall be a violation of these rules to advertise a bankruptcy sale unless the items offered for sale, whether real or personal, are from an active bankruptcy action. Before conducting an auction as a bankruptcy sale, the majority of the items in the sale shall come from the bankruptcy of one or more parties. Other items not related to or from a bankruptcy action may be sold with items from a bankruptcy action if specifically disclosed at or before the time of the auction. .0602E says that it shall be a violation of these rules to advertise any auction using such descriptive words as urgent, emergency, distress, or any other word which connotates liquidation of assets or that buyers will, for some extraordinary reason, be in a position to reap some unusual bargain without specifically disclosing in the written advertisement in a print size equal to the descriptive word the reason that the sale is urgent, the nature of the emergency, or the cause of the distress, etc. Similarly, point 0602F says that it shall be a violation of these rules to advertise any auction using such descriptive words as seized, confiscated, forfeited, or any other words which connotes a governmental action whereby items are seized or taken by a government department, agency, or commission and released or sold, or that the buyers will, for some governmental reason, be in a position to reap some unusual bargain without specifically disclosing in the written advertisement in a print size equal to the descriptive word the exact nature of that governmental action. Point 0602K deals with liquidation language. It shall be a violation of these rules to advertise any auction using descriptive words such as contents, stock, inventory, liquidation, or any other words which connotes that the items to be auctioned are present on the premises of a residence, business, building, or establishment unless the items were physically present continuously for 30 days prior to the signing of the contract or written agreement. Finally, 3 general rules about all auction advertising. Point 0602I, it shall be a violation of these rules to advertise for sale items which the auctioneer or firm does not intend to offer for sale at the advertised auction. J says, it shall be a violation of these rules for an auctioneer or auction firm to permit its name or license number to appear on any advertisement for an auction without reviewing the contents of the advertisement prior to its publication to ascertain its compliance with the applicable law and rules. The burden is on the licensee, a designated person, to make sure that the ads are correct. And then finally, point 0602L. At all auctions that include a buyer's premium, the amount of the buyer's premium shall be announced at the beginning of the auction, and a written notice of this information shall be conspicuously displayed or distributed to the public at the auction site. Again, these and the complete list of rules regarding advertising for auctions are found at 21 North Carolina Administrative Code 4B.0602. There is a great deal of information available to you at the board's website at www.ncalb.org. Information available on the Resources/News tab includes practice tips like we discussed before on topics such as contracts and advertising. There is a firm exam study guide there that you could download, and that's important because even if you're an auctioneer, it's helpful to read that study guide because it focuses on auctioneering law and rules. There are also 2 approximately 20-minute videos on firm exam prep, so that's helpful on law and rules as well. There are back issues of NCALB newsletters available on that page of the website, and various places throughout the website are downloadable copies of the auctioneering laws and rules for North Carolina, specifically North Carolina General Statute 85B and 21 North Carolina Administrative Code 4B. Ethics. Now we'll discuss ethics in general, then ethics as it applies to auctioneering, and then finally, we'll look at some case studies in detail. What are ethics? What are some descriptive words or phrases that come to mind when you think of ethics? Among those that have come up before include honesty, integrity, values, morals, golden rule, do unto others, and so on. As a matter of reflection, ask yourself, are you acting ethically as an auctioneer? Assuming that you are, would your past sellers agree with you? What about past buyers and other bidders? Let's say they don't agree with you that you are an ethical auctioneer. If a seller, buyer, or bidder has a negative opinion of your ethics, hopefully they're wrong. Hopefully they've made a mistake, and you really have more of a perception problem than an actual ethics issue. Both are a problem for you and for your business because word of mouth advertising is very effective in either direction, especially in this age of social media. What is the difference between character and reputation? Character describes who you are. Reputation describes how you are perceived. Both are important, especially for business purposes, but there is a distinction. Character is who you are. Reputation is what other people think of you. Remember earlier in this program, we discussed the North Carolina state motto at the bottom of the seal there, esse quam videri, which means to be rather than to seem. That's a whole lot like that distinction between character and reputation. Character being who you are is to be. Reputation being how you are perceived is how you seem. So our state motto is very close to that discussion of character versus reputation. Is it against the law to be unethical? More specifically, is it a violation of North Carolina auctioneering law and rules to be unethical? Let's take a look. Earlier, we read the 11 provisions in North Carolina General Statute 85B-8, which are the prohibited acts which could bring an assessment of a civil penalty or denial, suspension, or revocation of a license. Of those 11, certainly at least the following 5 deal with ethics. 85B-8(2) dealt with a continued and flagrant course of misrepresentation or making false promises, either by the licensee, an employee of the licensee, or someone acting on behalf of and with the licensee's consent. Number 4 was any false, misleading, or untruthful advertising. 5 was any act of conduct in connection with a sales transaction which demonstrated bad faith or dishonesty. 6, knowingly using false bidders, cappers, or pullers, or knowingly making material false statement of or representation. And then number 9, the commission or conviction of a crime that is punishable as a felony offense under the laws of North Carolina or the laws of the jurisdiction where committed or convicted, or the commission of any act involving fraud or moral turpitude. So certainly, those are examples of where it is a violation of NCGS 85B-8 to be unethical. What about the auctioneer rules? There are 16 provisions in 21 NCAC 4B.0404 that are grounds for license denial or discipline. Of those 16, At least the following 4 involve ethics. Number 15, failure to possess truth, honesty, and integrity sufficient to be entitled to the high regard and confidence of the public. Number 13, obtaining or attempting to obtain compensation by fraud or deceit. 12, engaging in unprofessional conduct. And 11, being incompetent in practice. For the purposes of 11, a licensee has been incompetent in practice if the licensee engaged in conduct which evidence a lack of ability, fitness, or knowledge to apply the principles or skills of the auctioneering profession. Failure to be a competent auctioneer is an ethical lapse because you have a duty to your buyers and bidders and a fiduciary duty to your seller. These are all examples of, yes, it is a violation of North Carolina auctioneering law and rules to be unethical. Ethical dilemmas involve analysis and choices. Some are very easy. An example of an easy ethical dilemma is when you notice that a cashier obviously gave you too much change. That's a very easy ethical dilemma to analyze and make your choice as far as what is right and what is wrong. Other ethical dilemmas are very difficult. What are some of the ethical dilemmas that you have faced? And also, what are some that you know of that some other auctioneer has encountered? What did you do? And what did they do? Since this recording does not allow for two-way dialogue, I'm going to list a few ethical dilemmas that can be difficult. What happens when an auctioneer finds an item in an estate and the auctioneer thinks that the owner of that estate doesn't know about the item? Another example would be, what does an auctioneer do when before an auction starts, he hears 2 or more bidders colluding? Sometimes that might be a problem, especially if one of those is the seller. What if you hear the seller asking or telling someone to bid for him? Especially if that's an absolute auction, then you've got a big problem. You also have issues with disclosure, even if it wasn't an absolute auction. Did you properly disclose who exactly can bid? What about when an absentee bidder asks you to bid on his behalf up to a certain amount? That is a practice that happens all the time, and you are providing a service both to that bidder, but more importantly, you're providing a service to your seller by expanding the universe of bidders. But for your live audience, did it give them the perception that shill bidding is going on and that there really isn't an absentee bidder? And also, since that absentee bidder does not know about the other bids, are you giving that person the perception that you're running up the charge if you go all the way up to the maximum that they authorized you to bid? Obviously, that won't be an issue in the very good case that you sell the item for a price higher than their maximum bid. Are there ever any ethical dilemmas involved in a pre-auction private sale offer? Whether it's one where a buyer came to you, you sought out a buyer, or a seller brought someone to you. Again, your fiduciary duty is to act in the best interest of the seller, but you also have a duty to be fair, open, and honest. This last one is not really a difficult ethical dilemma, but it's one that happens all the time and can really define who is an ethical auctioneer and who is not. And that is when that auctioneer recognizes that a bidder is unknowingly bidding against himself. What does the auctioneer do in that case? Whatever he or she chooses to do certainly will indicate his or her level of ethical standards. Many of you will remember the late Steve Proffitt. He was a lawyer who taught courses and wrote many articles on auctioneering law and also on ethics. He made reference to what he called the triangle of fraud. We can all be tempted toward bad judgment and unethical behavior by the triangle of fraud. And that the points of that triangle are need, opportunity, and rationalization. Ethics, also known as moral philosophy, is a branch of philosophy that involves systematizing, defending, and recommending concepts of right and wrong conduct. The term comes from the Greek word ethos, which means character. Ethics is a complement to aesthetics in the philosophy field of axiology. In philosophy, ethics studies the moral behavior in humans and how one should act. Ethics may be divided into 4 major areas of study. Ethics and morals can be considered synonyms. However, morals are beliefs based on practices or teachings regarding how people conduct themselves in personal relationships and in society, while ethics refers to a set or system of principles or a philosophy or theory behind them. Ethics is an advanced expression of morality. Morality is simply a statement about right and wrong. One lives according to one's morals, but adheres to one's ethics while doing so. Morals are the tools by which one lives personal character, and ethics stresses a social system in which those morals are applied. Here is a pretty straightforward concept regarding ethics, and that is the statement that there is no right way to do a wrong thing. Now let's talk about the word integrity. What is the definition of integrity? The word integrity stems from the Latin adjective integer, which means whole or complete. In this context, integrity is the inner sense of wholeness deriving from qualities such as honesty and consistency of character. As such, one may judge that others have integrity to the extent that they act according to the values, beliefs, and principles that they claim to hold. Integrity means doing the right thing at all times and in all circumstances, whether or not anyone is watching. True integrity is a way of life. It isn't one single act of doing the right thing. It's living a life of a commitment to doing the right thing. So integrity is a concept of consistency of actions, values, methods, measures, principles, expectations, and outcomes. In ethics, integrity is regarded as the honesty and truthfulness or accuracy of one's actions. Adherence to moral and ethical principles, soundness of moral character, and honesty. Steadfast adherence to a strict moral or ethical code, state of a system where it is performing its intended functions without being degraded or impaired by changes or disruptions in its internal or external environments, and strict adherence to a moral code reflected in transparent honesty and complete harmony in what one thinks, says, and does. These are all part of the definition of integrity. Integrity is doing what is right even when it's difficult. What is the value of integrity? Integrity is a core quality of a successful and happy life. It's being totally honest in all aspects of life. It's being truthful in all aspects of life. Here's a famous quote from Albert Einstein. Whoever is careless with the truth in small matters cannot be trusted with important matters. I think you'll all agree that how someone deals with smaller issues will often be a guide to how they will deal with bigger and more important matters. What about ethics and integrity in business? Ethical business practices are actions and attitudes held by a business or sole proprietor and its employees that are considered professionally and morally responsible. When a business does not have ethics in its everyday work atmosphere, the long-lasting effects eventually can be fatal to that business. The seller, the one you owe the fiduciary duty to, is watching closely at the auctioneer and the auction firm's actions from the start to the finish to see how he or she conducts the auction and presents himself and herself. So is the buyer. Successful business is built on trust of customers, employees, and the public. You should demonstrate ethics and integrity because it is the right thing to do. Integrity of a business affects everyone. You should be honest and transparent. You should be truthful in selling. When you market yourself and your service, you are obligated to deliver what is promised. Customer service integrity is following through and ensuring that the customer has a great experience. You will reap the rewards. Ethics and integrity are critical to your business, whether you are a large company or a sole proprietor. Your management practices are the underlying foundation for integrity, good business practices, and good customer service. What does being ethical and having integrity have to do with an auctioneer or auction firm business? Remember, auctioneers are entrusted with other people's goods, and upon the sale of those goods, they are responsible for the money received and dispersing those funds to the rightful owners. They have entrusted you to provide a service to sell their property at auction. Remember the name of that very high level of duty an auctioneer has to sellers? That's right, it's a fiduciary duty, an extremely high level of responsibility as a fiduciary for the seller. Now, some thoughts on business ethics in general. Business ethics are built on personal ethics. Business ethics require that you have a business plan. Otherwise, how can you do a good job for your seller? Business ethics apply internally and externally, not just how you deal with your clients and your customers, but also how you deal with your staff. Business ethics come from the boss. It's a top-down proposition. People will want to do business with someone that they can trust. It's important that you review all of your print and online marketing material for accuracy and professionalism. And of course, treat others with the utmost respect. So what's going on this slide? You could say that it looks like the salesman on the left is making his pitch and promising fantastic financial performance, while the client on the right is concerned about the risk he is considering taking. Don't take advantage of your client. Help them make informed decisions based on realistic expectations. Earlier, we mentioned a business plan and how it's part of good business ethics to have a strong business plan for the services that you intend to provide for your client. Have a good business plan that works for both you and your client. If it works, you'll both make money. If it doesn't work, try something else. Okay, so we've talked a great deal about what is involved in the North Carolina auctioneering law and rules, and we've also talked a great deal about ethics in general and ethics as it applies to auctioneers. As you are aware, there are some very serious potential repercussions for ethics lapses by auctioneers. The first involves license discipline, up to and including revocation of your license. There is also potential civil liability. Both buyers and the sellers that you owe fiduciary duty to could potentially seek and get civil judgments against you for an ethics lapse, and that can cost you money. In the most extreme cases, criminal convictions can even happen. That could involve restitution to your clients or somebody else. And also, in the most extreme cases, a possible loss of your very freedom. You can go to jail for ethics lapses involving your fiduciary duty to your seller. The board genuinely seeks to help well-meaning auctioneers who are trying to operate the right way. And that's why there are very real resources available to you, like I mentioned before, at our website. The practical tips, the law and rules, newsletters, and so on. That is also why there are continuing education courses to begin with. Unlike many occupational licensing boards, the North Carolina Auctioneer Licensing Board instructs its staff to be available to licensees to discuss compliance issues and general applications of the law and rules. We encourage you to call the office when you have a question about the law and rules. When you call, there is a caveat that the staff should always say if you call, and that is that the staff is not allowed to give legal advice, and anything discussed that you construe to be legal advice is not binding on the board. Still, we will go over what the law says with you and help you figure out how you want to apply that law to your certain situation. If still in doubt, you are always encouraged to consult your own legal counsel before proceeding. But remember, the board genuinely seeks to help well-meaning auctioneers who are trying to operate the right way. However, stealing from auction clients is a very serious ethical and legal transgression. And by the way, stealing is no ethical dilemma like those we've been discussing. Stealing by an auctioneer is a very conscious decision to take money or property from somebody that they had a fiduciary duty to, somebody that trusted them with their money and or property. But stealing from auction clients is a very serious ethical and legal transgression. The North Carolina Auctioneer Licensing Board not only cooperates with criminal prosecutions on request, but the board is very eager for its staff to provide information and to educate prosecuting attorneys on the schooling, testing, and continuing education that auctioneers have all been exposed to. Staff also makes sure that prosecutors are fully aware that auctioneers have a high standard of fiduciary responsibility and that they are also required to hold their clients' money in custodial trust accounts for sellers' proceeds. It has been the board's experience that once law enforcement agencies and prosecutors are made fully aware of the level of training that auctioneers have, that they've had, plus the fact that they are supposed to hold the money that's not paid on the day of the auction in an escrow account, and that they have that fiduciary responsibility. Once law enforcement agencies and prosecutors are fully advised of the level of responsibility that auctioneers have to their sellers, they then become more receptive to the notion of criminal prosecution rather than buying the defense from the auctioneer who misappropriated money that, well, I'm just not good at business, or I got behind on my bills. But once it's made known that there's no excuse for not holding somebody else's money in trust, then they become more amenable to prosecuting those few auctioneers that violate the trust they have to their sellers as the criminals that they are. That, of course, is very harsh language, but auctioneers that spend the money that's been trusted to them, or the property that is intended to be auctioned that was trusted them, are just that, criminals. And in 2017, just this past year, formerly licensed auctioneers were indicted for felony crimes of embezzlement in both Alamance County and Buncombe County in North Carolina. And in both cases, the NCALB assisted in the investigation and the prosecution of those cases. And both of those cases resulted in criminal convictions. The North Carolina Auctioneer Licensing Board seeks to help auctioneers follow the law, but the board's primary purpose remains to protect the public. There are presently as many as 3 current situations where the board expects it may be initiating communications with local law enforcement agencies and district attorneys to encourage prosecution of auctioneers who appear to have stolen from their clients. In its outreach to every single licensee and every single designated person, the board wants to be very clear that when a client is stolen from by a licensee, the board is going to do everything that it can to seek criminal prosecution. It's not just a matter of license discipline, and it's not just a matter of filing bankruptcy or civil liability. The board is going to help prosecute anybody that steals money from a client. Now let's revisit this slide where Steve Proffitt on ethics said, "We can all be tempted toward bad judgment and unethical behavior by the triangle of fraud," and that triangle of fraud being made up of need, opportunity, and rationalization. We're going to look at 4 real-life case studies and talk about what happened with them and try to apply the triangle of fraud to analyze those cases. The first case study we're going to discuss involved the following 2017 media headlines. Weaverville auction house under investigation, police say. That was at a television station website. Another one from the Asheville Citizen-Times newspaper read, former auctioneer charged with $150,000 in embezzlement. In this obviously very serious case, the executive director of the board went from Wake County to Buncombe County to visit with the investigator in that case. And he also spent a great deal of time with the prosecuting attorney discussing what the law requires in 85B and 21 NCAC 4B, discussed the fiduciary relationship, the fiduciary standard that the auctioneer is held to, the fact that he was trusted with the property or the proceeds from the sale of the property, and that's where an embezzlement charge comes from, is when you steal something that was entrusted to you. They were advised of the level of training that someone has to have from an auctioneering school before they're allowed to take an exam. They're advised about the 3.5-hour auctioneer exam. They were advised as to what that person's grade was on the exam. And they were advised as to the continuing education courses and the topics of CE courses that licensee had been exposed to in the years that he had been licensed. It is likely that all of this information was helpful in discounting any notion that the auctioneer licensee just made a mistake or didn't know what he was doing or didn't know what the law was and didn't have that fiduciary responsibility. He did, and he was prosecuted at a very high standard. His license was obviously revoked, and he was convicted of criminal offenses. Fortunately, he was able to meet a restitution order and pay back a large portion of the money that he stole from the various clients. It is the board's understanding that there are outstanding potential embezzlement charges that will be filed against him or indictment sought for him if he fails to pay the remaining roughly 25% of restitution that is due to his victims. So applying the triangle of fraud analysis to this, need, opportunity, and rationale, it is unknown specifically what his financial need was, but I guess it really doesn't matter why he was short on money. Opportunity-wise, he had great opportunity to steal because a lot of people trusted him with a lot of money or a lot of valuable property that he was to sell on their behalf. Rationale, why he thought he could get away with this, I don't know. We can speculate that maybe he thought it would just be a license issue where he'd lose his license and maybe get sued, probably get sued, and possibly dodge that by simply filing bankruptcy. That did not happen in this case. Successful criminal prosecution happened. Case study number 2. The auctioneer stated that the auction sale funds were deposited into the escrow account immediately following the sales and remained there for several months. He stated that the money was withdrawn from the escrow account for personal use, but was refunded to the account on a certain date. Toward the end of that month, he again withdrew money from the escrow account for personal use. So he stole the money, put the money back, and stole it again. Even though he intended to and did put the money back the first time, he was still guilty of stealing the money because it wasn't his. It was somebody else's money. It was his seller's money. He was holding it as a fiduciary. The auctioneer stated further, certainly had Mrs. X negotiated her checks following the sale instead of holding the checks, the money would not have been available for me to misuse. The auctioneer, the former auctioneer, wrote that in his response to the board. Obviously, his license was revoked, and fortunately, he was convicted of a criminal offense. We do not know what his need was as far as the need, opportunity, and rationale points of the triangle of fraud, but we certainly can tell what the opportunity was. He told us the money remained there for several months. So he decided he was going to spend it for his own use. And his rationale, he told us that too. To quote him, certainly, had Ms. X negotiated her checks following the sales instead of holding the checks, the money would not have been available for me to misuse. So he blamed her for stealing her money because she didn't cash her checks quickly enough. Of course, somebody else's money that you are holding in a trust account never becomes your money. You either hold it until they take it and accept it from you, and if you can't find them and you can't pay them, can't get it paid to them, then the board recommends that you contact the state treasurer's office and they will hold the money in the state's escheats fund as unclaimed property. But money left in your trust account that does not belong to you never becomes yours legally. Case study number 3. The auctioneer, or rather the former auctioneer, wrote to the board, I have run into some financial and medical conditions. I am aware that I owe her money. However, I am a little short right now. I do intend to pay her. I just ask for a little time and patience. I am hoping to stay in business and land a large estate. Emphasis added, land a large estate. A lot of problems with this. The person's license was revoked. There were multiple victims, multiple similar cases. And there's a good chance that criminal prosecution is going to be coming. Let's apply the triangle of fraud analysis to case number 3. What was his need? Well, he tells us in the first sentence, his perceived need was that he had run into financial and medical conditions. What was his opportunity? Well, with the clients he already had, the opportunity was they trusted him with their money and with their property. And even though he had a fiduciary responsibility to them because they trusted their money and property to them, he took their money and property for his own personal use. You can read that last sentence with the emphasis added and land a large estate. You certainly could read that to mean I'm looking for a bigger victim so that I can pay back my other victims. That's kind of unclear what he meant there. But regardless, his license was taken and criminal prosecution is likely coming. As far as his rationale for why he did what he did, we don't know. Maybe one day we'll find that out in court. But clearly, he violated his fiduciary trust. Case study number 4. There were multiple auction firm consignors contacting NCALB because they had received a letter from the auction firm's attorney advising that the firm owner, designated person, had encountered personal financial hardship and had converted the money from the proceeds from the auction sales of their property for her own personal use, and that she is working to come up with the money to eventually pay what was owed. A lot of issues here. And her license was voluntarily surrendered. There were multiple similar cases and formal complaints to the board. Triangular fraud analysis. Her need, she tells us in the letter to her clients, that she encountered personal financial hardship. Opportunity, all those clients trusted her as a fiduciary with their property and the proceeds from the sale of their property. Unfortunately, even though she was apparently, quote unquote, borrowing from the escrow account and ultimately couldn't keep up and pay back the money, it was stealing the first time she took it. Whether she intended to put it back, even if she did put it back, it was stealing as soon as she took it. And a random audit of an escrow account would show that, and that's something that the board is probably going to do more often, is randomly audit escrow accounts. In this case, the licensee was taking money from the escrow account for her own personal needs and then apparently using proceeds from subsequent auction sales to pay money that was owed to those that she stole from before they knew that she stole their money. Her intent was obviously to make it all good, but it was stealing the first time that she borrowed, whether she paid it back or not. I will say this, to her credit, that lady sold her house and made good on her commitment to pay all of her clients. So in this case, her victims all got paid. They did not get paid in a timely manner, and she had no right to take their money to begin with. But she did do what she said she was going to do, and she got them paid. She no longer has a license. I don't know if she ever got sued or not, but I do know that her clients did get paid, and to my knowledge, there was no criminal prosecution in that case. The important message for all licensees and designated persons from these 4 cases and from today's entire continuing education program is you must remember that you have a fiduciary duty to your seller. When and if you are the rare licensed auctioneer or designated person that fails to uphold your responsibility as a fiduciary, there are very serious consequences. As was discussed a few slides ago, the potential repercussions for ethics lapses are varied. 1, license discipline. You can lose your license. 2, if you don't pay people on time, you could be sued and you could have a civil judgment against you. You could lose money. But 3, criminal convictions will also apply if you fail to pay people at all. the board will very eagerly participate in a licensee's prosecution, and that can lead to an order of restitution and also a possible loss of your freedom. The stakes are very high when you have a fiduciary responsibility and you violate that trust. Regarding the triangle of fraud that we discussed previously, with the 3 points of the triangle being need, opportunity, and rationale, it is clear that substance abuse can certainly be a big factor in leading to the need point of the triangle. Now, I further want to be clear that in the 4 case studies that we just discussed, there was absolutely no indication that substance abuse had anything to do with their need. And substance abuse is not just about alcohol and so-called recreational drugs. Millions of Americans are addicted to opioids right now. This drug epidemic is rampant and pervasive. Every industry and every community is impacted. Addiction to opioids, including heroin, often has unexpected beginnings, such as the standard prescribed use of pain medication after surgery or an injury. Opioid addiction touches all walks of society. In fact, the likelihood of prescription opioid abuse actually goes up with age, not down. As widespread as this problem is, it is likely just a matter of time before one or more auctioneers betray their fiduciary duty to their sellers in order to financially support an opioid addiction. Other types of substance abuse and addiction are problems for all ages and all segments of society also. Don't let substance abuse damage your family. Don't let it ruin your career. Whether it is you or someone you care about, addiction is treatable. Get help before it is too late. Thank you for your time and attention. This concludes today's program. In order to renew your license for the 2018-2019 license year, those taking this course on North Carolina Auctioneer Law and Rules to include ethics and custodial account management through the board's website online will need to download, complete, sign, and send in to the board office the certification of course completion, which can be found on our website. It is similar to that shown in this slide. If you have any questions at all, please contact NCALB at 919-567-2844 or send an email to info@ncalb.org. Again, and this is very important, you must complete and return the certification of course completion form to the board in order for you to get credit for this mandatory continuing education course. Thank you and have a great year.